Thanks very much. Thank you, Ed and colleagues, for this invitation to chair this session. Noted that when Ed chaired this morning, he pointed out that his panel was so eminent that they needed no introduction. And not to be competitive, that's what I was going to say about my panel. So I will also keep the introductions very brief for that reason. But it's an absolute delight to be chairing this panel with our three distinguished speakers. So we move on now to the theme of the ECHR and the Venice Commission, the other anniversary that we're marking today, the rule of law and constitutional resilience across Europe. And the order in which our wonderful panel will speak is first Professor Sir Geoffrey Jowell, KC, who is Emeritus Professor of Public Law at UCL and was a member of the Venice Commission for more than a decade from the year 2000. Professor Angelika Nußberger from the Faculty of Law at the University of Cologne, of course, a former judge in Strasbourg from 2011 to 19, the last 2 years of which she was Vice President of the European Court of Human Rights. And she unites both of our themes today because she's also currently a member of the Venice Commission since 2020. I know, Angelika, you're also the author of a children's book in Germany, Free and Equal, which is aimed at, I think, sort of young teenagers upwards to convey human rights through storytelling, which I think is going to come up in the next panel as well. So you may wish to put your other hat on at that point. And then finally, Professor Laurent Pech from the Sutherland School of Law at University College Dublin, much more importantly, a former colleague of mine at Middlesex University, our former head of department, who's still very much missed, I should say. So without any more ado, I will hand on to Geoffrey Jowell. Thank you, Geoffrey.
Do I have to take this close to me? No. Can you all hear me? Through the mic? It's okay, is it?
Yes, thank you.
Oh, thank you so much. It's wonderful to be back here in these hallowed halls, in particular to see the Bingham Centre for the Rule of Law in such good hands under Jan Ansel Smith, and to see so many of my colleagues again, and to speak on this panel with Laurent, who I've known for some years, and also Angelika, we were together members of the Venice Commission, and indeed my successor as director of the Bingham Centre, Murray Hunt, is now one of the members from the delegates from the UK member on the Venice Commission. So there are lots of overlaps and interactions here. So happy birthday, Venice Commission. I'm talking about Venice Commission, of course, ECHR as well. And the Venice Commission, you must start in any account of the Venice Commission by recalling the late Professor Antonio La Pergola. Was he there in your time? Yeah, he was. He was a great public lawyer, an academic, a judge, and also a minister in the Italian government. In 1989, after the fall of the Berlin Wall, he had the foresight to propose that the Council of Europe create a new commission alongside the Court of Human Rights dedicated to assisting the countries of the former Soviet Union, including Russia itself, to write their new constitutions and institutions supporting democracy, human rights, and the rule of law. And thus, 35 years ago, was born the European Commission for Democracy Through Law, known for short as the Venice Commission, after the city where its 4 meetings a year are held. We all have to suffer for our day. I was privileged to be appointed as the first UK member, a full 10 years, by the way, after the Venice Commission was established. The government at the time did not appoint a member because they thought that since it goes back to Robert Spano's statement about our lack in this country of a proper constitution. Since we didn't have a proper written constitution, it was said it was assumed that we had no constitutional wisdom to impart to other countries. And if I may say so very modestly on behalf of this country, that turned out, I think, to be wrong. But the matter was rectified by appointing a member in 2000 at a time when there seemed to be, didn't there, Angelika, a kind of inexorable march in the direction of accountable governance. Those were heady days. There were always, of course, some countries in the former Soviet Union who dragged their feet, and Belarus never really qualified for membership. And Russia, however, on the other hand, seemingly was galloping along towards democracy, human rights, and the rule of law under at least Presidents Gorbachev and then Yeltsin. And its Chief Justice, Zorkin, is actually cited in Tom Bingham's book on the rule of law from a statement really extolling the virtues of human rights and the rule of law. He turned tail, as did so many others in Russia at that time. And ironically, during my 11 years at the Venice Commission, the country that was perhaps most reluctant to move forward was Ukraine. And I used to sit next to the Ukrainian member around that magnificent table in the Skula. And because UK, Ukraine, we sat in alphabetical order. And the Ukrainian delegate, Professor Sergei Holovati, and I used to discuss the rule of law. He was particularly concerned that Ukrainian judges would continually uphold measures taken to infringe human rights, and then would proclaim that they were following the rule of law because everybody was subject to these rules. They were completely certain and applied universally. And so I countered by telling him of something of the history of rule of law in this country. It was a concept that was brought to the fore by the famous Professor Dicey in the 19th century. His definition is by no means perfect, to say the least, but in essence, he was seeking to control arbitrary power. And he also believed in a kind of equality, that law should be applied equally to everybody. It was what we now call a somewhat thin conception of human rights, but it was the rule of law. And it was then in the 19th century, in the 20th century, that constitutionalists such as Professor Ivor Jennings would really knock the brains out of Dicey's rule of law by saying things like, he was one of these Whigs, he was not like us, progressive socialists, liberal thinkers wanting welfare states. And under Dicey's rule of law, you could justify child labor, for example, as long as we're equally forced and universally applied. So that was pretty well the end of the rule of law. It had a huge, those attacks had a tremendous, I am simplifying, of course, but they had a tremendous impact by and large, only to be resurrected really from the 60s on with the growth of judicial review in this country and the notion of implied common law constitutional rights. But the great thing that Sergei Holovati, my Ukrainian colleague, did was to set in train the Venice Commission's work on the rule of law by asking the General Parliamentary Assembly of the Council of Europe to request an opinion from the Venice Commission to identify a consensual definition of the principle of the rule of law to allow its, quote, practical application. And I was appointed chair of that subcommission, as they're called, and it was by no means easy to gain support for the notion of the rule of law among the then 47 very diverse countries of the Council of Europe. It took 4 or 5 years. It was only in 2011 that we came to our conclusions and produced the report. And I think it may be obstructive just briefly to consider what those objections were. Why did it take so long? There were four main sources of objection. And they're raised, by the way, continually, even now. And we had great difficulty in overcoming them at that time, particularly because of the diversity of the various countries on the commission. The first objection came from those who took the line of the Ukrainian court, namely that rule of law is a purely formal concept, and it allows, they see from the other side, it allows the application of unjust laws, the Jennings point of view, so long as they're properly enacted and so on. And this justifies bad or unjust laws. That was the first objection. The second objection was that it was doubted by some that there was a fit between the concepts of the rule of law and analogous European concepts, such as Rechtsstaat, Estado de Derecho, État de droit, or the term employed by the Council of Europe, prééminence du droit. And this argument was elided often into a third argument, namely that the rule of law was really an Anglo-Saxon concept, only for common law countries, and it didn't resonate in non-common law, non-Anglo-Saxon systems. And some people would go and say it's from the north rather than the south, for the old rather than the new democracies, for the developed world rather than the developing, and so on. And you still get this argument these days. And then finally, and I'm afraid this was probably the biggest hurdle, was there were some, even in the Anglo-Saxon common law world, who would say that it means all things to all men and women. It's a vague concept. It was what is being called an essentially contested concept of little practical value other than as a set of formal procedural requirements of good governance. And we'd had some witnesses whom we thought were our friends who came over from the London School of Economics and other places to Venice, and we thought that they would extol the virtues of the rule of law. They disappointed us by saying that it's essentially vague and we should get onto something. Human rights were much better as a way into control of government, with friends like those who need enemies. But what helped finally to permit the entire commission totally unanimously to coalesce behind this document on the rule of law, finally published in 2011, was, I have to say, Tom Bingham's book, The Rule of Law, which was first published just in time in 2010. And this provided a key way in, an understanding that the rule of law is both clear, an essential element of any liberal democracy, and he demonstrated this in a unique way by breaking down the rule of law into separate ingredients. It's not one thing. We don't want one long definition. There was one provided, which came from the UN into his book. But he just sort of slightly disregarded that long definition in favor of what he called 8 ingredients. It's like a cake with different ingredients. And these ingredients are the ones that were adopted. His 8 ingredients we slightly boiled down without losing any of them into 6 ingredients. And certainly during my time at the Bingham Center, we found that for the public understanding of the rule of law, it was probably best to reduce those 6 ingredients to 4, because it sort of it countermanded the notion that rule of law is vague and ununderstandable. And easy to understand these 4 ingredients, which were, first of all, the notion of legality, number 1. Everyone must comply with the law. No one's above the law, including government. This includes private as well as public power. It includes international law, and law must also be enforced. Okay, so that's legality. Secondly, certainty, legal certainty. Dicey was very keen on legal certainty. This was almost his primary consideration, that law should be relatively stable and predictable. That's why he didn't like any discretionary power whatsoever. Law, of course, can be changed, but only after fair warning. And as Dicey also said, certainty is the enemy of arbitrariness. We now know that discretionary power is absolutely essential for any complex society, but it has to be controlled and constrained through judicial review and so on. So there's legality, certainty, then there's equality. Huge element of equality in the rule of law, particularly a sort of formal equality, maybe non-discrimination as well, but like cases must certainly be treated alike. And this comes through in all the definitions that we had seen. And then, but there's the final requirement, or the final ingredient, which is that access to legal rights, access to justice. You have to, it's no use having a law if it can't be challenged. And when it is challenged, it must be done through a fair trial. If it goes to a court, there ought to be other ways of challenge as well, before an independent judiciary. And this kind of characterization seemed to knock on the head all of the four objections to the rule of law. First of all, it shows that the rule of law is not ruled by law. I'll never forget the famous and excellent Chief Justice of South Africa after apartheid, Arthur Chaskalson, once saying the rule of apartheid laws were part of the rule of law. I agreed with virtually everything he'd ever said, but I couldn't ever agree with him about that. He was focusing purely on the first formal element of the rule of law, legality. But surely a country where there was detention without trial, rank discrimination, to say the least, couldn't fulfill those other ingredients of the rule of law. So secondly, as shown by the acceptance by the Venice Commission's 47 nations, rule of law was shown not to be a private reserve of any one country or of only of the West or the Anglo-Saxons or the North or the South. Thirdly, the document decisively refutes the notion that the rule of law is vague and essentially contested with no practical value. You can test this simply by just removing any one of those four ingredients. Take away certainty, take away equality, take away any one of them, and you cut into the heart of the essence of through the heart of a democratic society. And immediately taking any of those ingredients out reveals the ominous contours of an autocratic state. So the document was accepted unanimously in 2011. There was then, it had a short checklist, which was then expanded in another document after another committee was formed, which created a larger checklist. That checklist is now being further revised. And to complete the history, the Venice Commission documents have been very widely cited since then, including by the Parliamentary Council. I've got a huge list, if anyone's interested, of the times they've been cited and where, including by the Parliamentary Council of the Council of Europe, the Venice Commission's decisions itself, the Court of Justice of the European Union, and the European Court of Human Rights. And it has also influenced other documents that have emanated, particularly from the EU, and and there's a recent document from the European Law Institute called the Charter of Fundamental Constitutional Principles of the European Democracy. It's a 2024 document from the ELI, which virtually adopts the entire definition of the rule of law from the Venice Commission. Now, as I said, that's not to say that the argument is over.
And despite its authority of the authority of that document and of the subsequent decisions citing it, it's still under attack. And one of the issues with which we also grappled at the time and as resurfaces constantly is this notion of the relationship of the rule of law with human rights in particular and democracy. And as we've seen, there's a thin version, the Ukraine version, the Jennings version, articulated most clearly by Professor Joseph Raz, which states that the rule of law is not coterminous with human rights. And it does require law to be clear, accessible, not retrospective, independent judiciary, but that's about it. And of course, Raz famously said that if a state has instituted slavery and is a wicked state, it is a wicked state, but not necessarily one that offends the rule of law. Bingham disagreed with that. And Jonathan Sumption has recently come in his book on democracy, siding with Raz on that. He does, acknowledge that there are elements to the rule. He does acknowledge this, but he says certainly this does not. That has limits. The Venice Commission took a slightly took a view that rejected wholeheartedly the view that it's a totally thin concept, the Ukrainian concept, but it not altogether accept the thick version, which is that all of human rights are within the rule of law. The rule of law has to cover all of human rights. And it did so on the ground that most of our fundamental rights overlap, or many of our fundamental rights overlap with the rule of law, such as judicial independence, access to justice, and so on, non-retrospectivity. But there are, but not all. The right to education has nothing to do whatsoever with the rule of law. And indeed, the rule of law can go beyond human rights, particularly when it adopts what we might call principles of good public administration, or the right to administrative justice, if it is a right, namely that arbitrariness and irrationality offend the rule of law, and other rights such as the independence of the legal profession, even though they may not actually be involved in any particular human right. So in the end, I'll end soon, it seems important not to ask too little of the rule of law, but not to ask for too much of it. Why is it necessary to conflate the rule of law and human rights when, despite their overlap, they provide a dual protection for constitutional democracy? Why is it necessary for the rule of law to colonize all of human rights? In essence, the rule of law works to protect democracy from autocracy on the one side. That's what it's all about. And on the other side, to protect us from anarchy. It's a mechanism of accountability. Human rights overlap with that, but it does different work, granting different entitlements which do not directly impinge on the rule of law. And it's surely unnecessary to conflate these two fundamental features of a constitutional democracy, especially at a time when they are under such attack, not only in some of the European states that were so full of democratic hope 25 years ago, but also in some of the old democracies who should really know better. Thank you.
Thank you so much, Jeffrey, for that masterful sweep through the history of the Venice Commission's contribution on the rule of law, and indeed the UK's contribution to the Venice Commission and your contribution to both. One of our questions before lunch referred to Connegate, who we all hold in such esteem and miss so much. And I think also the spirit of Tom Bingham is definitely in this room today as well. But I'll move on now to Angelika Nußberger. Thank you. The floor is yours.
Thank you. Thank you so much. It's a huge pleasure to be here with you in the Bingham Center and to be on this panel and to follow up on Jeffrey Jowell. Indeed, we were sitting together in the Venice Commission, but you were sitting with you like with UK, and I was in Ukraine, and I was sitting with Germany, so on the very other side of the table, but we could throw back and forth balls concerning the rule of law in the Rechtsstaat. So this was always very, very good times. Well, let me begin with a spectacular theft of the crown jewels in France. Something very different, you see. Within a few minutes, a very small group of people managed to steal the state's most valuable treasure. The result was not only the loss of the crown jewels, but also the loss of confidence in the state's ability to protect what is truly valuable. The thieves lost one of the tiaras on the streets of Paris. It was found again, damaged but repairable. The other jewels are missing. There's great fear that the diamonds have been removed and that it will be difficult to find them again. But if they are found, it will also be possible to restore the jewels almost to their form of law. Why do I start with French crown jewels? Because I think in rule of law, the independence of the judiciary is something like the crown jewel of rule of law, and we have to see some parallels with this theft and with the loss of confidence. So obviously, the loss of rule of law is not so spectacular. We cannot have a scenery like that, but still it's visible. It's also not happening within a few minutes, but the loss of rule of law is rather a slow and long-term process, can even go on over decades. It's also, well, we don't know, perhaps not only a small group of people, 5 people in France, but there might be, with a loss of rule of law, there might be even only one or a few who have a bad intention to destroy rule of law. And if they get the others to cooperate, it will go downhill. Let's just quote one sentence, and I don't tell you who said it. He who saved the country does not violate any law. If you have something like that on the top of the country, this is the one where everything starts and then the others stop. So next point, loss of trust. I think that is something similar. You lose the trust that the state is able to guard the jewels in the museum, or you lose the trust that the state is able to guard independence of the judiciary. And it's very difficult to restore trust. What is lost it may be necessary to rebuild it over the years. And last but not least, repair. I said you can put in the diamonds and the crown if you find it. It's a question of good luck to find it or not to find it. But with rule of law, it's much more difficult. If you have manipulation and you have the wrong judges on the wrong positions, you cannot just repair, you cannot just put something back. And if you have, even more so, judgments adopted by the wrong judges who came to their power by manipulation, what do you do when these judgments have entered into force? It's not so easy. And this is now where the European Court of Human Rights kicks in. Because, as you all know, the European Court of Human Rights, in the famous Gudmundur case versus Iceland, and then in all those Polish follow-up cases, it said that the fact of having a manipulation behind a judge taking a specific position, that is a violation of Article 6, tribunal established by law. So the diagnosis of the court was correct, obviously. It's a tribunal not established by law. But diagnosing the disease is not yet curing it. And so let's look what the court said. It said in the individual case, well, you may have a trial. In the concrete case, Gudmundur, it was a specific question that the lawyer did not demand retrial. And the second question is, what do you do with all the other judgments which have been adopted by the same judge or the same tribunal which was not established by law? And there, let me just quote the court. The court further considers that in accordance with its obligations under Article 46 of the Convention, it falls upon the respondent state to draw the necessary conclusions from the present judgment and to take any general measures as appropriate in order to solve the problem that have led the court's findings and to prevent similar violations from taking place in the future. Necessary conclusions, appropriate, very open. That being said, the court would emphasize that the finding of a violation in the present case may not as such be taken to impose on the respondent state an obligation under the convention to reopen all similar cases that have become res judicata in accordance with Icelandic law. So it says that something has to be done, but it's not concrete what has to be done. And it says that something has not to be done, not to reopen all cases. But that's all the guidance the court gives. Now let's take a critical view. Is it fair in the individual case? I want to cite the dissenting opinion of the chamber judgment. There, my colleague said, the majority open a Pandora's box by offering to convicted persons an argument indefinitely available to challenge their conviction on the basis of grounds, as in the case at hand, that had nothing to do with the fairness of the trial. So whoever is convicted will be unhappy and has always a reason completely unconnected to ask for a retrial. And if you have a civil case, you have always more parties involved. So the problem is what to do. First, what do you do with those who are now sort of occupying the place of a judge? I call them, just to abbreviate, the wrong judges. What do we do now with the independence of the judiciary? And now I come to the Venice Commission, because we have the Venice Commission checklist. And the Venice Commission checklist, it summarizes the points Jeffrey has explained to us in questions, because we should check if we apply this. And these questions imply what is the good thing to do. And so, concerning access to justice, we see, are judges appointed for lifetime or until retirement age? Are grounds for removal limited to serious breaches of disciplinary or criminal provisions established by law, or where the judge can no longer perform judicial functions? Is the applicable procedure clearly prescribed in law? And now we have the problem. We have as a model the appointment until retirement age. So these wrong judges are appointed until retirement age. And now we say, as Venice Commission, grounds for removal is serious breach of disciplinary or criminal provision. No, it's a manipulation of the procedure of being nominated, or not being able to any longer to perform judicial functions. There's no disability in this context. So it doesn't match. What the Venice Commission says doesn't match with the court's judgment. And problem two, the reopening of the proceedings. And there, Jeffrey has stressed res judicata is an important element, crucial element for legal certainty. It's actually even a principle of general international law that res judicata should be taken seriously. So there we are with our problems. At the same time, it was necessary for the court to react in some way to these manipulation in bringing judges to certain positions. Now let me go shortly into two case studies to show you how difficult all that is. The first is my own country, Germany. I want to take you to the eastern part of Germany, Thuringia. There we had elections last year, and we had, out of 88 seats, we had 32 for the AfD. So they have more than 1/3, and they could block and can block the installation of the election of the members of the selection committee, because they have 1/3 and they need 2/3, so they can block it. So for 1 year, it's not possible to have a new selection committee for judges, no new judges. And as you can imagine, if you have no more judges, you get a real problem in the judicial system. So now what they are discussing, they discuss to take the old selection body, which was legitimate under the old election, to take them to start appointing judges. But constitutionally, it's clear the mandate is only for the period, for the legislative term, and then they can sit for a transitory period. But can they sort of stretch the transitory period to appoint all new lifetime judges? We don't know. I would say no. I would say, from my understanding of the constitutional law, that this is against legitimacy. That is a transitional provision. It's not possible. It creates a huge insecurity if they use this old committee now and they have new judges. Whoever is judged by those judges can go to Strasbourg and will have a violation found. Complete. So, and this plays into the narrative of the AfD, because the AfD says, well, the state is not functioning, it's failing. Let's see, you don't even know if the judges that the judgment that these judges adopt will be that. Second example, more well known, Poland. There, the whole dismantling of the judicial system is well known. We had the dissolution of the Judicial Council, and then it was elected newly by the parliament and not by judges as before. And the question was if this is an anti-constitutional. So now, if you look at the concrete provision in the constitution of Poland, it says 15 judges chosen from amongst the judges of the Supreme Court, common courts, administrative courts, and military courts. It's a use of passive voice, chosen by. It doesn't see who chooses them. And this was interpreted that judges have to choose them. And if it's the legislator, it's wrong. But that is an interpretation of outside, not of the Polish Constitutional Court, but from outside. Nevertheless, the Venice Commission and the court were unanimous to say, I quote, enable the legislative and executive powers to interfere in a severe and extensive manner in the administration of justice, and thereby pose a grave threat to the judicial independence as a key element of rule of law. So it was condemned by all experts from outside. Now, I was involved in the assessment of, and that is now the question, how can we restore rule of law? How can we repair the crown jewels? The new Polish government had a new law, what to do. And they asked us as the Venice Commission if that is in line with European standards. And they proposed to have an ex tunc invalidation of all wrong judges, an ex tunc invalidation. But that went back until 6 years. That went back 6 years because they had been now working for 6 years. And the Venice Commission said, sorry, this is not possible. And I quote what he said. Based on the principle of the separation of powers, the Venice Commission and DGA consider that it cannot be declared through a law that all the appointments made by the National Judicial Council in a particular time frame are null and void. It cannot be. It would be a wholesale invalidation ex tunc of all the resolutions of the Polish National Judicial Council, does not fit into the rule of law concept, as it would, among others, fail the proportionality test. So the answer to Poland was, you cannot do it as you plan to do it. And then they also asked about judicial recourse, if those wrong judges who are now losing their jobs can have judicial recourse. And the Venice Commission said access to justice. They said yes. But they said also perhaps not a suspensive effect, because then they would be longer and longer. So this is not necessary. And then concerning the judgments, the Venice Commission said that the judgments who have entered into force can be revised only if no more ordinary appeal is possible in a certain time frame and if the complaint has been raised before. So they said under certain conditions. But now let me tell you what that means. We have 1 million judgments adopted by the wrong judges in Poland, and we have 3,000 wrong judges, and we have 100 constitutional court judgments, which are also considered as wrong judgments. So just to tell you the dimension. What happened? Nothing happened because the president would not sign any of the law. They hoped that the new president would be elected and would be cooperative. He was not. And the Minister of Justice was dismissed. And there we are. We don't know how to repair rule of law in such a situation. So what can we draw out of that? It's we see all the mechanisms, we see the goodwill, we see the problems that have happened. We are at a loss how to repair it. Both those who were wrongly nominated and also the judgments. But even more though, I think the problem is now the lost trust. Because the problem is you don't think if you go to a judge, this is going to be the one who has the right and competence to decide the case. I just want to bring this example to show you that it's all, we try with our best intentions to respond to problems as we see this backlash problem. Of course, now the lessons learned are do something before it happens. So that is what we all share. You can have a deblocking mechanism, like for the situation in Thuringia. You should have something. You can have a legal basis for recalling judges in such a situation. You can sort of learn from the problems of others, but still, it's difficult. And I just want to show you the difficulties and share with you my reflections on them. And last point I want to mention, Jeffrey said this rule of law checklist is now about 10 years old, and the Venice Commission decided to revise it. So we are in the process of the revising, and we hope, I don't know if we manage, but we hope to adopt it now in December. And there we have a new section which is called challenges. And under challenges, we have this problem of restoration of rule of law. And there, for the time being, I don't know if it's going to be there in the end version, but for the time being, we have a question there which summarizes what I talked about today. And that is sort of what I would see as a condensed message of all these negative experiences. The question in the rule of law is a departure from basic principles of the rule of law, such as the principle of legal certainty, the principle of res judicata, and the principle of irremovability of judges, justified by a pressing need and proportionate. So that is how we try to bring these things together to then give advice to say, well, in this situation, it's okay. And in this. Thank you very much.
Thank you so much, Angelika. I enjoyed your analogy with the French jewelry heist. I must try and use that sometime. And I think you've also reminded us very much there why, even if the rule of law isn't essentially a contested concept, there can be contestation within discussions about what it consists of. There's very aptly chosen case studies. So our third speaker is Professor Laurent Pech. Over to you, Laurent.
So thank you very much, Alice. It's always a pleasure to meet again. just a brief reaction on the Polish case, actually, because I'm going to talk to you about the rule of law, but from the point of view of EU institutions and the extent to which they have relied on the Venice Commission studies and the case law of the Court of Human Rights. There was a recent judgment last month, very interesting. This is the very first time the Court of Justice of the EU has ruled that judgments issued by defectively appointed judges must be considered null and void as a matter of EU law. So this is adding to the complexity of the picture. So now we know as a matter of EU law, it's actually settled at the level of the principles. So any defectively appointed judge within actually the meaning of the legal test devised by the European Court of Human Rights, then their internal measures plus the judgments they participate to must be considered null and void as a matter of EU law. So in cases connected to EU law, it does bring plenty of additional issues, such as when does a national dispute fall within the scope of EU law, but at least at the level of principles, we have new guidance from the Court of Justice. But today I'm going to tell you, so essentially I'm going to summarize about 20 years of the EU's institutions' reliance on the case law of the European Court of Human Rights and the Venice Commission. Not an easy task, because the way the EU institutions have relied on either the case law or the Venice Commission doesn't always match, and they have made a multifaceted use of both as informal sources. But before I get to the EU's rule of law toolbox, just a broader context, as I'm sure you're all aware in this room. So we are in the midst of a global rule of law recession, according to the World Justice Project. This global rule of law recession started in 2016. In the EU, we were pioneers in a way, because the EU's rule of law crisis started in 2010-11. So before it became a global phenomenon, the rule of law crisis was identified as such in 2010-11. And on the back of this, this is what I'm going to tell you about. And so-called rule of law toolbox was developed by the EU institutions. But as far as the EU is concerned, the situation has not improved since 2010-11. In the latest World Justice Project Rule of Law Index, out of 27 member states, 18 had declining rule of law scores this year. And this came just a few months after the EU Commission spoke of a positive dynamic across the EU. So I don't know who's right or who's wrong. I would tend to side with the World Justice Project on this. But in any case, so the good news is I'm not going to go through each of the tools I'm going to briefly list. I'm just going to pick and choose to give you a flavor of the EU's reliance on either the case law of the Court of Human Rights or the Venice Commission. You are looking at the EU rule of law tool. Most of them were not used or designed to address rule of law backsliding before 2010. Some of them are new. I'll mention later the annual rule of law cycle. This is the most important permanent monitoring tool currently used in the EU. And just to let you know already, I'm going to give you a bit of data. I just checked before coming here. And I was not surprised, but I didn't know exactly how many times the Venice Commission will be cited in all of the EU reports. So we have 27 country reports plus 4 reports about 4 selected EU candidate countries, and we have a transversal report. So if I've merged all of this report together, I did Control F, and I found 143 references to the Venice Commission, just so in a single package of reports. And this is more than the number of references I could find from 2010 to 2020. So in a month, more references to the Venice Commission than in the previous 10 years of the rule of law crisis, but more data later. We have also response tools. I'm going to mention very briefly Article 7 and the rule of law framework, and also the general conditionality mechanism. So altogether, essentially, we have, depending on how you count them, we have between 10 and 12 rule of law tools to address rule of law backsliding. I'm very critical of the development of the toolbox, but this is not the topic of my presentation. But my general position is the EU has spent too much time designing a tool rather than actually using what we had at the time. And then we end up in a situation in 2025 where it's worse than ever. I've been working on this for many years. It's getting worse every year. Even though Poland was the positive news last year, but as you heard, it's easier to destroy the rule of law than restoring it. Nothing is surprising in this respect. Now, I'm going to tell you that I have selected an EU primary law tool, an EU secondary law tool, and then an EU soft law tool. And just to show you the extent to which each of these tools is using or not using or relying on the ECHR case law and or the Venice Commission. Article 7, wrongly known as the EU's nuclear option. This is wrong, I'm not going to explain why, but just remember it's wrong to label it as a nuclear option. It's a pre-rule of law crisis tool, so it did exist in 2010, even though actually initially when it was first drafted, I checked in this 2003 communication, the rule of law is almost not mentioned. However, so this on the slide, by the way, it's not the text of Article 7 you're looking at, it's the text of a communication from the Commission explaining how the Commission intends to interpret and apply this treaty procedure. And in this communication, it's very interesting, not only because it's a pre-rule of law crisis communication, so it shows you a different type of thinking at the time, but there are very few references, not a single reference to the Venice Commission, and just a single reference to the case law of the European Court of Human Rights. I'm going to tell you about the pre-Article 7 post-rule of law crisis, and then you're going to see it has been a sea change. You see the Venice Commission and the European Court of Human Rights mentioned everywhere. So interestingly enough, however, let me add a qualification here. This is a pre-rule of law crisis tool, which was used post-rule of law crisis twice with respect of Hungary and Poland. And in the context of so-called formal hearings, actually member states have been relying a lot on Venice Commission opinions and the case law. But you wouldn't know that because the minutes of these hearings are very brief, almost cryptic. But I used to work for a member state in the context of Article 7 hearings, so kind of I had access, so I can confirm, but not evidence too much, that there was extensive reliance by national governments in respect of the situation in both countries. Now, let me move on to secondary rule of law mechanism, the so-called conditionality mechanism or rule of law conditionality regulation. This is here where you're going to find the Venice Commission's definition of the rule of law essentially codified in EU law, even though what happened is that the European Commission really kind of, found a lot of inspiration. I didn't want to say plagiarized the Venice Commission's study, but I mean, that's the kind of cross-fertilization we want to see. So in 2014, the EU Commission essentially copy-pasted the definition of the Venice Commission, and this definition found its way in many years later in the conditionality regulation. And not only is it interesting to see that the EU's rule of law definition is almost identical to the Venice Commission's definition, but the Venice Commission gets an explicit mention in recital 16 of the regulation. But you can see also reference to Greco. Essentially, you can see some references to consortia bodies in terms of assessing when this instrument is going to be applied. It has only been applied once to Hungary. And in this context, there were a few references to Venice Commission studies regarding the situation. And Greco actually even more than the Venice Commission in this context. It's not surprising because it was mostly activated in the name of fighting corruption in Hungary. But this is a post-rule of law crisis instrument. This is another post-rule of law crisis instrument dating from 2014. The informal name is pre-Article 7 framework. And if you compare this to the 2014 communication of the Commission regarding this tool to the 2003 communication regarding Article 7, then you can see the sea change in terms of relying on the Venice Commission and the case law of the European Court of Human Rights. I'm not going to give you more data, but essentially, you have 4 times more references to the Council of Europe understood globally than in the 2003 communication. And also, perhaps worth noting, it was activated in respect of Poland. And in this context, there was extensive reliance by the EU Commission on the findings of the Venice Commission. It was actually the first time I saw a really mutually reinforcing relationship between the Venice Commission and the EU Commission. I've been an EU lawyer for a long time. Before 2010, actually, the dominant feeling was that actually the ECHR would take over from the Venice Commission, but it didn't happen. But pre-2010, there was some suspicion or fear or concern that essentially the EU would be relying less and less on the Council of Europe's bodies, but that didn't materialize. And I think we realized that it's actually a good thing to have two different organizations. I get back to this relationship and the mutual benefits of this relationship. I did tell you about this EU soft law mechanism. This is the latest, the most important, according to the EU Commission. Its most important monitoring tool. This is the one leading to the publication of many reports, possibly too many reports. All of the reports combined this year, it was close to 670 pages. At some point, it was 2 years ago, it was closer to 900 pages. Takes a lot of time to read them all. Consider yourself lucky, you don't have to. What is interesting, so I told you Venice Commission cited 140 times, but it can be cited by different actors. So it doesn't mean that the EU Commission itself directly relies on the Venice Commission, because sometimes contributors to this exercise can also rely, and then they are mentioned in footnotes. But you can see it's a sea change compared to many years ago, the first 10 years post-rule of law crisis. The European Court of Human Rights judgments were cited also about 120 times. And the Council of Europe, so sometimes there was specific reference to a specific body, but 450 plus times. So if you transversely, but the number of references does differ depending on the report you are checking for obvious reasons. You get a lot more studies on the Venice Commission regarding the most problematical member states. Something which is new and perhaps worth noting as well, I don't think this is well known. The European Commission itself has decided from time to time in some circumstances to explicitly mention the Venice Commission when designing country-specific recommendations. Each of these country rule of law reports, they tend to come with between 4 to 6 so-called country-specific recommendations, and you have some examples on the slide. So the Venice Commission was mentioned in the country report for Poland, and this was actually a country-specific recommendation. Same for Romania. In the context of Bulgaria, this was not a country-specific recommendation, but there is something new. Now, the Commission is adding a lot more data on non-compliance with judgments of the European Court of Human Rights in each of the country reports using the data produced by a network of NGOs. This is new. Actually, the paradox here is that there is no data on non-compliance with judgments of the Court of Justice of the EU. There are different reasons for that, but it's a bit of a strange feature of this exercise. And so now I'm going to tell you about the case law dimension. So I have told you about essentially mostly the EU political institutions' reliance on the Venice Commission, the case law of the European Court of Human Rights. I'm going to tell you about the judicial institution of the EU. And before I give you some concrete examples, just I wanted to highlight the huge increase in the number of rule of law related cases adopted by the Court of Justice. This is not my graph. This is a graph from an article published by Professor Tommaso Pavone. But his data does actually correspond to my data. He has a broader understanding of what is a rule of law case, but it doesn't matter. The big picture is that there has been an exponential rise in the number of judgments regarding rule of systemic threats to and systemic violations of the rule of law. And you can see that it started really after Orban regained power in Hungary in 2010, and then the previous British government gained power at the end of 2015. Actually, this is what led the Commission to become more strict or more active in terms of pursuing systemic violations of the rule of law in the case of Poland. This invitation to speak today actually provided me with a great excuse to look at the case law more closely. Actually, I discovered that reliance does depend on a type of action. I'm not surprised by this finding, but essentially I'm going to give you an example of the main forms of action before the Court of Justice, and I'm going to show you that in fact reliance on the case law of the European Court of Human Rights and the Venice Commission does differ depending on the type of action. Where you have essentially the cases where you can find the most extensive references to the case law and the Venice Commission opinions are preliminary ruling requests. So before I get to that, I'm going to tell you about infringement cases and annulment actions very briefly. And before I do that, I forgot this slide. Also, in addition to judgment, you need to pay attention to opinions of advocate generals. They tend to be very happy to rely on not only the case law of the Strasbourg Court, but also increasingly on the Venice Commission studies. And this is actually an infringement action, which is pending, not yet decided, but to be decided about Hungary. And you have a footnote 42, you can see an explicit reference to the Venice Commission study from December 2021. I have found about 40 opinions in the past 15 years directly citing studies from the Venice Commission. And it depends again on the type of action. But this is an infringement action. And but overall, when it comes to infringement actions, actually very few infringement actions do explicitly refer to either the case law of the European Court of Human Rights and the Venice Commission. The reason for that, I think, is that so here in this case, this is about the Polish muzzle law. So a very important infringement judgment regarding Poland's rule of law crisis. And there is only one mention to a judgment of the European Court of Human Rights. And that's a mention made by the Commission, not by the court. The court actually just does not answer this case. And in the rule of law infringement actions I found, there is barely any references to either Venice Commission or the Strasbourg Court. I think this is because this is a form of action where the court has to decide whether national law is compatible with EU law and doesn't want to rely on non-EU sources for that. I think that's my, we need to talk to the President of the Court of Justice if he still wants to talk to me. So this is another form of action, Article 263 cases, annulment actions. Very rare. So you have very few cases where the Venice Commission is explicitly mentioned, more where the case law of the Strasbourg Court is mentioned. And here, this is actually a great example of the Venice Commission studies being actually relied upon by a government actively undermining the rule of law. In this case, the Hungarian government tried to argue that the EU Commission of the Rule of Law was in violation of the Venice Commission's definition of the rule of law. The Court of Justice disregarded this claim, which had no merit whatsoever. But interesting that the Venice Commission studies may be relied upon not only by pro-rule of law actors, but also by anti-rule of law actors. I'm seeing this more and more often. So, and what I call anti-rule of law actors are trying more and more to instrumentalize Council of Europe assessment to see whether they can be used to challenge the findings of EU institutions. In 99% of the cases, they do that with bad faith. I mean, in 100% of the cases, they do that with bad faith. In 99% of the cases, it's also plainly wrong. Now, the form of action where you can see the most extensive reliance on the Strasbourg Court case law and the Venice Commission studies is Article 267 cases, preliminary rulings. This is a recent example. And this is a very interesting example to the extent that the Court of Justice does explicitly rely on Strasbourg Court's finding to find the Polish body not to be a court within the meaning of EU law, and therefore the case is rejected as inadmissible because the Court of Justice got questions from what is formally a court under Polish law, but no longer deemed to be a court under EU law. This is interesting also. I mean, I'm a bit critical of this approach, but because this is the first time and the only time so far where the Court of Justice has essentially subcontracted an EU law task to non-EU bodies. I cannot explain that in much details, but essentially the Court of Justice has said, if someone is going to challenge whether a national court is in fact a court, we're not going to do that ourselves. We're going to wait for findings from either national courts and or the European Court of Human Rights. So this is why I speak of subcontracting this task. The previous case law before that was, this is an EU law question. We actually don't care about non-EU law findings. Obviously, a simplification of the case law. But this is essentially very much the Court of Justice simply following, or at least taking a strong account of the findings of the Strasbourg Court, and the Strasbourg Court's case law is very comprehensively and carefully assessed by the Court of Justice. A bit more transversal data now. Essentially, this is the data my dear colleague, Professor Carlos Closa, put together when we were working together as part of an EU-funded project. This is looking at the period 2010 to 2020. As you can see, he found about 86 EU documents, including one judgment from the Court of Justice. He excluded opinions from Advocate General. And now, I just told you about the July 25 edition of the Annual Rule of Law Report. If you add Venice Commission references, European Court of Human Rights plus Council of Europe, you have essentially more than 500 references. And that's just a single package. So essentially, you can see the exponential rise in the references and actual reliance on the findings in a different context to support activation of rule of law tools, to support judicial findings. I couldn't be more subtle than this, but also in the context of the case law, you have reliance by the applicants, reliance by the defendants, reliance by the Advocate General, and reliance by the court on a case-by-case basis. And also national judges, I forgot actually, I found about 80 cases in the past 15 years with all these actors relying in one way or another. So it has been a sea change compared to the period studied by Professor Klose. This is my last slide, and this is essentially what I would like to develop in my contribution, should there be a publication arising out of this conference. So just very briefly, compared to the situation before the rule of law crisis, where essentially there was the dominant feeling of thinking was essentially the EU would not need anymore to rely on consular bodies because the ECHR was supposed to again authority the kind of a role in terms of tasks to be allocated to this agency. After the rule of law crisis, this thinking was set aside, and in fact, the EU Commission and other EU bodies started quickly understanding that how beneficial it would be for the EU to actually, I don't want to say hide, but rely on external findings to actually strengthen the justification of activating specific instruments. He went as far as the Court of Justice itself, doing what I called, not in a nice way, possibly subcontracting some EU law tasks to non-EU bodies. It has had many positive impacts. I think the fact, for instance, that the EU Commission now is looking at non-compliance data as regards the Strasbourg Court is directly beneficial to the consular system. They should do the same for the Court of Justice. There are some issues, however, there are more benefits than shortcomings, that is, so let me be clear. What I found also is example of selective reliance by EU institutions. So they pick and choose the findings which they find the most useful from their point of view. Sometimes EU institutions are going to strongly defend the rule of law. Sometimes they don't want to defend the rule of law. So they're going to be a bit of selecting the bits and pieces you want, especially the political actors, not the court so much. I would say the Court of Justice possibly should not be subcontracting EU law tasks to non-EU bodies, because what did the court do so? I mean, my interpretation is that what wanted to delay finding EU, so national courts from EU member states, not to be courts within the meaning of EU law. And a nice way of pretending to be worrying about this without actually doing anything about it is to say, well, I cannot decide this, it has to be decided by other courts. But for the Strasbourg Court to decide that the national court is not a court, it takes many years before you get a judgment on the merits. And in the meantime, the Court of Justice is accepting to answer questions from non-courts within the meaning of the EU. It's a complicated topic. And then I would say both organizations, they need to prevent autocratic, what I call autocratic contamination or contagion. And in this respect, I would say the Venice Commission, especially, I can think of at least the Polish members, they should not be on the Venice Commission at all. One of them is an illegal judge appointed to a non-court as per the case law of the Strasbourg Court and the case law of the Court of Justice. Both institutions need to essentially strengthen the system to prevent essentially autocratic actors from interfering or contaminating decision-making processes. In the EU, we have several issues, especially within the Commission. And arguably, we have at least one EU member state which is no longer a democracy, and therefore technically shouldn't be voting on EU legislation. And yet, because Article 7 I told you about never is yet to lead to anything, we are in a situation where EU law is in part adopted by a government from a country which is no longer a democracy, not according to my assessment, but according to many assessments from democracy specialized bodies. So essentially, the bottom line is it's a good thing that the EU institutions, including the Court of Justice, have relied on the case law of the Court of Human Rights more extensively. Same applies to a reliance on the Venice Commission studies. However, both organizations need to deal more promptly and more forcefully with what I call autocratic actors. So thank you very much.
Thank you, Laurent, for that wealth of data. I should say that Laurent, of course, is not just here with an academic hat on, but has been a kind of scourge of autocrats across Europe. So much so when he left Middlesex, we had printed on his cake and a mug, I think. What was it that was the slogan that was said about you by Orban? Enemy of the people, or something like that. So
You called many names.
exactly.
I try not to remember them.
Well, it is a badge of pride. Right, so we have, I think, 15, 20 minutes for questions. As this morning, if you could say briefly who you are and keep your question brief. Yes, Anna.
Yeah, so
Do we have a mic? Sorry, have you got the mic, Linda? Sorry to interrupt, just to make sure everybody can hear. And then I saw one at the back there as well. Come to.
yeah, so Angelika, University of Glasgow. So a lot of your, at least the presentations of this afternoon, and also the presentations of this morning, really focused on the rule of law and judicial independence, and this afternoon in particular on the connections that there might be between the EU law, ECHR, and the Venice Commission. I want to maybe ask a question about something else than the judiciary, because I think if we want to draw lessons from Hungary and Poland, I think these governments, these populist governments, have not only dismantled the judicial system, they have dismantled other systems as well in society. And I'm particularly interested in the media system and the electoral regulation system. So in both Hungary and Poland, it has been an orchestrated attack on liberal democracy. And of course, I understand the focus on judicial independence and the rule of law, because I think this is really the core of who we are as constitutional lawyers. But I think it's difficult to speak, it's more difficult to raise the issues, for example, of media and elections. And on that topic, I want to hear, maybe that's a little bit more addressed to Angelika, the extent to which, or maybe also to Laurent, the extent to which, in fact, the Court of Justice of the EU or the European Court of Human Rights, for that matter, would rely more on Venice Commission findings when it comes to particular topics at the expense of others, because the Venice Commission also has guidelines and checkups for other things than the rule of law and judicial independence. For example, on the media system and the system of electoral of elections. Do you get a sense of courts, the Court of Justice of the EU or the European Court of Human Rights, in their relation to the Venice Commission, that they actually tend to select, and I should say maybe provocatively cherry pick what they want from the Venice Commission, depending on a certain number of priorities, at the expense of other areas that I think have also been the victims of populism in the examples that we know?
Thanks, Ella. Did I see a hand at the back? Yes. This one, sort of near the back there, Linda. Thanks.
Hi, I'm Katerina Hadjistavri from the University of Reading. I wanted to ask a question specifically to Angelika, but it's open for everyone on the panel to ask or to answer. For many Eastern European academics, the term restoration of the rule of law can be a little bit problematic because it presupposes that there was a stable culture of the rule of law as a principle in Eastern Europe. So I wanted to ask if perhaps since we're talking about and thinking and looking at the rule of law, maybe it's about we should look at establishing it and strengthening it rather than just restoring it.
Right, and Kustrin, yeah.
Hi, thanks a lot for your presentations. Kustrin Mistrefi from Utrecht University. When we talk about the Venice Commission, it always starts with the inspiring story of what it did in the East. And I think it did a great job. But I'm wondering what could be the challenges for the West. The Venice Commission has still not been tested fully to respond to rule of law and democracy crisis in all democracies. We have had very few to none opinions for many countries, and some that we have had, like France, I would say are very controversial. And so I'm very curious, perhaps for Angelika, I would love to hear your views, but as a member, maybe, a more nuanced answer, but also for Jeffrey, what do you think could be the challenges? Do you think Venice Commission is equipped to deal with democracy and rule of law challenges in all democracies? Thank you.
Thanks, Christian. Should I slip a fourth question if there is one? Don't see a hand for now, so let's go with those three. So are certain issues or areas neglected, like media and electoral regulation? Is it problematic to talk of restoration of something that perhaps was never there before? And has the Venice Commission been tested fully in relation to old democracies, or what are the implications? Yeah. Should we start with Angelika, since a couple of those were directed to you, but please feel free to comment across the board.
Yes, thank you. Well, I think I have to stress for the functioning of the Venice Commission, like a court, the Venice Commission cannot look for its own where it wants to make it, to give an opinion. So it's not ex officio that the Venice Commission can sort of scrutinize their problems. We are going to write an opinion about it. So they react. The Venice Commission only reacts, and it only reacts when it has a specific request. And most of the requests we had in the last time were actually about independence of the judiciary in all variations, and almost exclusively coming from Eastern and Southeast Europe, indeed. If there is nothing coming from the West, we cannot give any answer. If there's nothing coming on media law, but media law is already quite far away of the expertise of the Venice Commission. Election law, yes, we have a lot of opinions, and we have really a specialization on election laws, and there are a lot of answers, and also rule books and extracts of best of Venice Commission opinions. I mean, whatever body you have, it's not omnipresent and has to be specialized in order also to be credible. So I think the Venice Commission is really good at rule of law questions. It would not go so much into human rights questions as such, because there it's just the court. So your question about the media, I remember this Georgian case we had in the court where it was argued the takeover of one media in Georgia would be the end of free media in Georgia, and we have to have an interim measure, etc., etc. So that is where these problems can be dealt with. And is the court equipped for Western European countries? I think it's perhaps the other way around, that many of our Western European countries don't have a place for asking the questions to the Venice Commission. So we have so many other institutions which fill this gap. Whereas in Eastern European countries, it's really when you have a constitutional change, you really wait for this answer from outside. We are happy that we do have a few opinions on Western European countries in order not to have this disbalance too big. And with the backlash that we are seeing, it can be that it's revived and that it's getting more important. But once again, we have to wait for being asked before giving answers. And concerning the restoration of rule of law, absolutely. I mean, that is what in Poland is an important argument, actually, of all, I would say. Nobody really says we have to go back exactly where it started, but it's always agreed that something has to be improved. So it's not really going back, but still it's possible to see a beginning of the process with the interference into the Constitutional Court first and then into the other courts. So there's a starting point, and you can say these were manipulations and you have to get back. But if you are back, you're not in paradise. You still have to have many more improvements. I think that's agreed by everybody. And we are not sure about the word. We use restoration. We also use recovery, like a patient that's recovering. But you are right. It's not a process like with my jewels, which are back and then they are in the vitrine and you can look at them. It's not the same.
Thank you. I'm glad we're keeping the jewelry metaphor here. Jeffrey or Laurent, do you want to add to any of that?
Sure. Shortly after I went on to the Venice Commission, I have received a number of, on the first morning of the Venice Commission meeting, the members of the Parliamentary Assembly of the Council of Europe come into the hall and sometimes ask a lot of questions, sometimes even of members. And I was asked out of the blue by a Dutch member, Mr. Eric Jurgens. Remember him? Yeah. What is this business of your Minister of Justice appointing judges in the UK? At that time in this country, it was the Lord Chancellor who appointed our judges. And we're trying to persuade Central and East European countries that this should not be the case. There should be independent commissions or some other kind of independence, and politicians shouldn't appoint judges, separation of powers, etc. And I said, well, I'd like you to know that our Lord Chancellors have been very independent in practice, in fact. And he said, but it looks bad. And we can't sell this to the East and Central European countries because they keep on saying, look at the UK, leading democracy, one of the oldest democracies, and so on. The people were a bit surprised because, again, it wasn't usually the old democracies that were challenged by the Venice Commission. But Mr. Jurgens persisted, and he was authorized to come over to the United Kingdom. And he met a couple of judges, and he went to a committee of Parliament, and he gave evidence saying that this was wrong. Well, for all sorts of other reasons, possibly, but also, I think, for this reason. Just about a year or two later, this country then stopped, took away those powers from the Lord Chancellor, which breached the notion of separation of powers, and in this country appointed an independent judicial appointments commission. So that was the first time that I saw a Western country invite the attention of the Venice Commission. And then there was Mr. Berlusconi in Italy, who started buying up all the newspapers as he took more and more power and seeking monopolies and so on. And the Venice Commission actually seized that issue with great trepidation, because Italy was the country that really persuaded the Council of Europe to set up the Venice Commission, gave it its premises in Venice, and so on. So that was that case. And I think there have been some other cases where these countries, and it must also be realized that the Venice Commission's remit also goes beyond Europe. So it was very active at the beginning of the Arab Spring in countries like Tunisia, when it had sort of hope for democratic change, in other countries, Bolivia, Latin America, Chile, and so on. So it's not all Europe, the 47 countries of Europe. On the other question about restoring it or establishing, I agree with that. I was just looking at that was the point I made about South Africa. There was not rule of law, in my view, under the apartheid years. And the new constitution, all it says on this, the rule of law is one of the top principles under the new South African constitution. And it calls it, the Republic of South Africa is one sovereign democratic state founded on the following values: human dignity, non-racialism, supremacy of the constitution, and the rule of law, founded upon, whether or not there before or instituted after. That is the situation, they said. Now, on the question of taking over the judiciary, the media, these are not, I think these are, in a sense, rule of law issues, because they all form part of the playbook of autocracy, don't they? And we're seeing it time and time again. I was recently in Serbia. My colleagues have recently been in Hungary. You see it in the United States of America, of this attack on the media, attack on the independence of the judiciary, eventually leading to intimidation of individuals, of lack of fair trials, sometimes going on from there into torture, taking on NGOs,
clipping their wings in one way or another, all part of, I think, rule of law, human rights, and democracy, totally intertwined.
Thank you, Jeffrey. Laurent, do you want to?
Yes, very quickly. So actually, the EU's country rule of law reports include a section on media freedom. So you have plenty to read on media freedom or the lack thereof in many countries. And this is nothing new. Actually, when pre-Article 7 was activated for the first time against Poland, two reasons were given to activate this tool, attacks on the Constitutional Court and taking over of the public broadcaster. So the issue when it comes to the EU is it's not that electoral issues also are not tackled. Problem is that when they are violated, when there is a dismantlement, capture of the media, plus undermining of free and fair elections, the issue is not that this issue are not talked about, is that the EU fails to actually sanction these developments. So I can find you thousands of pages on the changes to the electoral system in Hungary, not a single infringement action. Regarding media freedom, saying except the excuse of the EU when it comes to media freedom is that there was not enough substantive EU media law to use to actually pursue or get cases off the ground. Now this has changed, so there are actually a few pending EU media law cases, including one regarding Hungarian radio. So this is going to be the precedent-setting case. In here, the main issue is not the issue is that it was a bit too late, too little, too late, and the court, for some reasons, have been sitting on this very important judgment for too long. When it comes to electoral law, so you're going to have a new Article 7 report from the European Parliament at the end of this month, and you're going to see there is a section on how Orban has essentially made sure that there is no free and fair elections in Hungary, but Hungary has not lost a single euro on this basis. And the argument I'm hearing is that there's not enough EU substantive law to actually go after member states using the legal forms of action I've mentioned. But this can be tackled under Article 7, which is a political instrument and not a legal tool. So we can do a lot. It's just a lack of political will to actually tackle both.
Thanks, Laurent. We're slightly over time, but I was going to ask Ed for permission to carry on. And indeed, the next question is from Ed, so I think we've had got permission. And then also from Jowell, so two quick questions to finish up. Thank you.
Or she knows I'm ill right now. Hi, Jowell Grogan, for the purpose of this question and knowing Laurent, UCD Sutherland School of Law. Would the panel agree that rule of law degradation is just a symptom of the seeming incapacity of modern democracies to deal with both immediate crises of economics, standard of living, healthcare, employment, along with existential crises, climate, security? I'm suddenly worried about the length of this question. And so any curative effect of rule of law has to be with those challenges in mind. And if so, how?
Thank you, Lynn. Thanks very much for the panel. I have learnt a great deal and a lot to comment on it, but I won't comment just because we want the question then. Thanks so much, Laurent, for telling us about the impact the Venice Commission is having and the court actually in another context. Actually, my question is about the Venice Commission's impact within the Council of Europe context itself. I asked because I became aware that there were a number of Venice Commission reports, very good reports in relation to Russia, going back many years, but especially 2012, 13, 14, 2016. And my question relates to what impact, if any, they have within the Council of Europe context, but not to undermine the importance of those documents, but perhaps to make a point, my feeling being that they need to be taken more seriously in the Council of Europe context. My sort of general comment question there.
Thank you, Ed. Laurent, do you want to start with this one? We can work on the
rather not.
No, okay.
It's a very good question, as you would expect from a former colleague of mine. I'm not going to try to answer it. I'll reserve my answer for later because actually it's quite a sophisticated question. I'm not disagreeing with the underlying diagnosis. Essentially, my quick answer would be when there is rule of law backsliding happening. So perhaps I don't disagree with the overall diagnosis, except perhaps I'm going to make a different point. In my experience, at least as far as rule of law backsliding is concerned in the EU, it has never seen evidence that it's a bottom-up phenomenon. I've always seen this happening in a top-down version. So there is never, I've never seen an EU member state where there is popular demand for democratic and rule of law backsliding. This is actually materialized or manufactured from the top. If you think about Hungary and Poland, in both cases, they never ran platforms saying, well, vote for me, I'll destroy the constitutional system, and I'll do that in the name of the will of the people. So yes, there are challenges, and to some extent, perhaps the rule of law backsliding does essentially crystallize other issues. But as a rule of law backsliding expert, if I can describe myself as such, what I've seen is actually it's an elite-driven phenomenon used by some political entrepreneurs to actually just conquer and gain power. And also, if they're lucky enough just to gain power once, by the time they're going to be new elections, the only thing they have to do is dismantle the checks and balances, rig the electoral framework, and then it's game over, no matter whether there is no longer any popular will for this. So that would be my kind of indirect answer to you. Very good question. I'm not going to try to answer this because I'm an EU expert, not a Council of Europe expert, so that's my excuse. I'm going to leave this difficult question to better experts.
Angelika.
Yes, I mean, there is a lot of interaction within the Council of Europe. So when we now started the process of revising rule of law, we try to find how many quotations where it's referred to. And yes, I mean, the Venice Commission is really quite often referred to in cases of the European Court, especially these rule of law cases with the Polish judges. You have really long parts. And Russia, the agent law is something that is sort of creeping everywhere. Though the NGO, the disempowerment of NGOs is an important aspect. So the Council of Europe, I mean, you have to see it as one international organization, which has the Venice Commission and the court as the most visible parts. And all the others do refer to it in one way or the other. I would say central is the Parliamentary Assembly, because they send us the most interesting or most controversial requests as a rule, and then we answer. When you see a meeting of the Venice Commission, you see this institutionalized, because you see in the morning, on Friday morning, we have a report from the Parliamentary Assembly, we have a report of the Commission of the local bodies, etc. So very many of the different bodies of the Council of Europe, and there is this exchange and dialogue. Some quote us more often than others, but there's interaction, and luckily so, because it understands itself as being one organization under one roof. And there as well, I would just say first things first. So when you have, and that's just what we now observe, I think Poland and Hungary were just exemplary. When you want to have a different agenda, you start with a judicial branch, because if you have judges who stand up, like in Hungary and Poland, you had very strong constitutional courts, and they would strike down laws that go into a direction that is not considered constitutional. When you change them first, you can govern much easier, and that is why rule of law is, for all of us, like mechanic of power. It's in the center of the mechanic of power.
The Venice Commission does two things, really. First of all, in response to individual countries' submissions of issues to it, it will respond to, is this constitutional? Does this fulfill the expectations of a modern liberal democracy in Europe? That's the first question in relation to specific questions. The other one is there's the general documents. The rule of law was one of those. There are a whole lot of others. There's one on referendums, there's one on electoral processes, and a number of other issues. And I've been quite struck when assisting with constitutions in different parts of the world. Most recently in a couple in the Caribbean, we want to set up a different ombudsman system. And we would like to do it along the lines of the Venice Commission, along those principles that the Venice Commission recommends. And I've had that 2 or 3 times recently. It's gone into that area as well. So I can't answer your question about generally in the Council of Europe, but I think we must just note that it extends. I mean, the other thing is, let's say your question. Well, one of the solutions to your problem might be to introduce socioeconomic rights. I don't know if that was at the back of your mind. Not really. And I wouldn't recommend it at this particular sensitive time, not the moment, however much we might want them generally. I think just not at the moment, not on the agenda just now, because of the just what the other side would like us possibly to do. It may be that standard of living, so on, conditions of life have prompted all this. It may be there's just a taste for autocracy. And I must get this off my chest because it has nothing to do with the questions. I hope you won't cancel me as a result. But the worst offense to the rule of law in recent days has been this random shooting of boats in the Caribbean and outside Venezuela and Colombia by the Trump government without a trial against people who may or may not be criminals. And it's an arbitrary killings, absolutely extraordinary. It's a very good, very short piece by David Cole, a wonderful American lawyer, on that subject in a recent edition of the New York Review of Books. Phew, I've got that off my chest.
All with you on that one, Jeffrey. So apologies for running over time, entirely my fault, but it was too interesting to stop. So thank you very much to our panel.